Oh, I get it now. Okay. Miss Cuchira, I don't have your attorney. You should be calling in or something.
Wait a second, the judge doesn't even know the lawyer's name. That's your first red flag, folks. When your own representation is a mystery to the court, you know this hearing is headed for chaos. Buckle in.
Cuchira, what is it? Cuchira? Cuchira. Okay. Don't need to go there. Go here. One 651 9.
Please try again. The number you have entered has not been recognized.
Oh, why not? Six, 5, 1, 7, 8, 9, 6, 5, 4, 5, 6.
Please try again.
You try it without the 1.
Try it without the 1. I think I've always had to do 1, but we'll see. Maybe it's a 612 number.
You have entered has not been recognized.
I'm gonna try looking him up. That's what I'm gonna try to do. He's disbarred. Oh.
Not yet.
Well.
And boom,
Wisconsin.
there it is. Disbarred, not suspended, not reprimanded.
He's only
Disbarred.
disbarred
That's
in
the legal
Minnesota.
equivalent of being kicked out of the game
Minnesota.
entirely. Can someone check if
then.
the bar gave this guy a lifetime ban,
Prominent
or just
Twin
a
Cities,
don't call
Michael
us, we'll
Padon
call you?
disbarred.
Non-Wisconsin. There's
Okay.
a pending case.
Oh, well.
He's only disbarred in
Just
Minnesota.
in Minnesota. Just in Minnesota. Alrighty then. Prominent Twin Cities Michael Padon disbarred. Prominent Twin Cities attorney Michael Padon disbarred. Well, his number is not recognized, so
Maybe he thinks he's disbarred in Wisconsin, because I know that Minnesota filed a complaint against him in Wisconsin on
I'm gonna
October
probably
17th.
say you need a new attorney. Probably what I'm gonna say. Probably. Do you pay him? I'd probably get your money back. Probably do that. Or ask for it, but sorry. Yeah, because that's the new news is prominent Twin Cities attorney Michael Padon disbarred. Not just suspended, disbarred. Cut, throw, gone. Okay? So, I'm going to give you some time to find somebody else. All right?
For what it's worth, he never filed a discovery demand and we haven't provided any.
I don't know how much you've paid him. You don't have to tell me. But I would try and get that back. Just friendly advice. All right, so.
Yep, the judge is giving friendly financial advice in the middle of a criminal hearing. That's how far off course this has gone. When the bench starts moonlighting as consumer protection, you know your defense hit rock bottom.
Did it take you a lot of time to save what you needed to get to him? Oh, wait. Okay, Miss Cuchira, Cuchira. I'm gonna get it, I promise. Miss Cuchira, why don't you come have a seat up here? Because I'm gonna guess you don't want him anymore, and he can't even probably practice anymore. So can we just remove him?
Yes.
And then we can just talk?
Yeah.
All right. We will go on the record in the matter 24 CM 213, State of Wisconsin versus Casey Cuchira. The state appears through District Attorney Kevin Schmidt in person. Miss Cuchira appears in person without counsel Michael Padon. The court attempted to call Michael Padon's number 3 times. All times it came back that this number is no longer, doesn't exist. The court searched for Michael Padon's contact information. When the court did a search for Michael Padon to get additional contact information to call Mr. Padon to notify him of his tardiness for today's hearing, big headline from January 4th came up saying prominent Twin Cities attorney Michael Padon disbarred. So that just leaves me to believe that perhaps he's not able to represent Miss Cuchira, and Miss Cuchira has personally paid for his services. So Miss Cuchira, you have a few things that you need to take care of. I'm going to guess that even hearing that news, even if by some chance, some grace of God.
Let's rewind that. The client had to remind her attorney about court. Imagine your Uber asking you for directions. That's not just irresponsible, that's malpractice knocking on the door with a subpoena.
He may still have his license here in Wisconsin. Hearing that he's disbarred in Minnesota probably gives you a little bit of angst.
And I had just contacted him Monday to remind him that we had court, and he never mentioned it.
Oh, well, kind of interesting. Did you contact him on the number I just contacted him at?
I can give you the number.
I would love it if you could, because I just called this number and it says it doesn't work.
Yeah, 612-669-4542.
Okay, well, that's not the number that I have, and that's not the number that came up. I don't know. And here's the thing. It's up to you and whatever you want to do. If you want him to continue as your attorney, that's your right. If you don't, that's your right too. Completely whatever you want to do. I called the case because you have $1,000 posted because you failed to come to court. So there's $1,000 posted. And what I was going to do was going to see if you wanted him to continue. If you didn't, I was going to remove him, and I was going to see if there was an offer, and I was going to see if there was any restitution. But I'm just going to ask if there is any restitution, because I don't have any disposition supplement. No, there's no restitution here. And so I'm not even sure where this case is going. I don't even know what's going to happen. Off the record, your attorney stated that there, and I'm noticing in my electronic file, no demand for discovery has been done yet.
Yeah, I thought that was kind of odd myself.
Therefore, it's kind of at a still, nothing's happening. So I don't know what you want to do. We can't talk about the case or where it's going or even an offer if you're keeping Mr. Padon as your counsel. He fails to appear. You said you talked to him on Monday, reminded him. You, the client, reminded the attorney. You, the client, reminded the attorney that there was a hearing. That usually goes the other way around. Like usually the attorney has the job of reminding the client, but good for you for being responsible and reminding your attorney who has failed to appear. All right. And again, it's not the court's job to even contact him to appear. He should be appearing, especially when the court gave him permission to appear by video. And he's not appearing by any means. I have Zoom up and there is no appearance.
The judge just low-key gave her a gold star for doing his job. Honestly, she's showing more courtroom discipline than her own lawyer. Is it too late to give her pro se representation and a robe?
Okay. So I'm not going to put you on the spot. I'd like to know if there's an offer, but I'm just going to kind of do a quick little turnaround to give you time to think about what you want to do. Maybe talk to attorney or ex-attorney Padon and figure it out. Mr. Schmidt.
Offer would be a ticket for $346,675 sub 1. That's owner's liability for failure to stop after accident, which is, according to the bail schedule book, 767.50.
767.50. And what was the statute?
346.675 sub 1. The owner liability version of it is a ticket, not a crime.
All right. So you can think about it even more. And again, I don't even know what's going through your head right now. Okay. I don't know what's going through your head. You probably have a lot. But
Honestly, I'm okay with just going ahead and proceeding without Mr. Padon.
and you want to make the intelligent, knowing, and voluntary choice to remove him as your attorney right now?
Smart move. Sometimes, accepting accountability isn't just the mature thing, it's the tactical one. With the disbarred ghost of a lawyer and no discovery filed, this could have spiraled fast, but she just might have saved herself a world of trouble.
All right. So therefore, the court will strike him and will withdraw him from the record as your counsel. And so you can understand, and now I'm going to see if you understand the offer that's been presented, all right? You have been charged with the crime, hit and run, as a misdemeanor. This hit and run misdemeanor crime has a maximum possible penalty of up to $1,000 fine and up to 6 months of jail, okay? Mr. Schmidt has made an offer to you to amend it to a ticket, all right? To a ticket for $767.50 under owner's liability for failure to notify of an accident, okay? You have $1,000 posted. That would cover a ticket if that's what you wish to do. I can give you time to think about this and have you come back in the next week or so. We can take care of it here today. Whatever you want to do. I don't want to put you on the spot. This is a lot for you to think about.
I'm okay with just taking the ticket and just going ahead and getting this over with.
You want to accept the responsibility, be accountable for your actions, and take a ticket for the fine.
Yes.
All right. Mr. Schmidt, formal motion to amend under the owner's liability for failure to notify of an accident.
So made.
Court will grant that. How do you wish to plead? Either no contest or guilty. Doesn't matter. I'm okay with either. No contest. Court will enter a no contest on your behalf here today. I will assess $767.50. You have $1,000 cash bond posted. That will go towards this ticket. The remaining will be sent to the person, the individual who posted it, to the address that they provided, okay?
Yep.
All right. Do you have any questions? Good luck. I'm sorry. Good luck. All right. Thank you. We are adjourned. Can you hear me?
I can.
Excellent. Mr. Anderson, can you hear me?
I can, Judge.
Excellent. Thank you. We will go on the record in the matter 24 CT47 24 TR 210, State of Wisconsin versus Clint Coleman. The state appears through District Attorney Kevin Schmidt in person. Mr. Coleman appears by telephone conference with approval of the court. His counsel, Bruce Anderson, appears by video conferencing capability, again with approval of the court. We're set here today in this matter for a status conference and essentially a final pretrial. The court has received a memorandum from the state, which the court did go over with Mr. Anderson. I believe it was a few days ago on January 13th concerning discovery and the video that the state intends to play at the jury trial. Mr. Coleman was unable to appear at that hearing due to the fact that it was short notice. The court wanted Mr. Anderson to have the ability to review that discovery and that video and to be able to speak with Mr. Coleman and give one last shot to figure out the matter if it's able to be resolved and where we're going, since we have the jury trial scheduled for this coming Tuesday on January 21st. Mr. Anderson, can you please update the court?
Well, yes, Judge. I have not been able to talk to Mr. Coleman about this. He had called my office this morning, as I expected, and then called back and said, well, I was in court in Polk County, and then called back and said that his phone was difficult and that he would appear at the hearing once he found another phone. So I've not talked to him yet today.
All right.
Court was told him. Okay.
So I am going to read the memorandum in the record. Memorandum from the state on January 8th, 2025 to Honorable Melissa R. Mogan from Kevin Schmidt, District Attorney, Ray, State v. Clint Coleman. This memo is to the court to update it on the state's attempt to comply with the discovery statute, the scheduling order, and protect the case against any claims of ineffective assistance of counsel. While preparing for trial, the state noticed that the defendant has never filed a discovery demand and therefore no discovery has been provided. The state intends on relying upon body cam footage that depicts the defendant highly intoxicated, hugging a deputy and telling the deputy he loves him, admitting to driving, admitting that he shouldn't be driving, and other significant admissions. The state is providing discovery today, even though it has not been demanded. The state is concerned about the possibility the defendant has made the decision to go to trial without actually reviewing the evidence of the case. Thank you. Electronically signed, Kevin Schmidt, District Attorney. So that is the memorandum, and that basically gives a gist of the body cam footage that the state intends to play at the jury trial on Tuesday. I need to have Mr. Anderson have time to speak with Mr. Coleman, and I need to have it done today, and I need to have a hearing, a status today, because we are on the tail end of time here with the jury trial scheduled for Tuesday. And again, it is scheduled to go on Tuesday. So, Mr. Coleman, when can you make it yourself available to have a very in-depth, thorough conversation with your attorney today?
As soon as we get done with this hearing, I suppose I'd call him.
All right, Mr. Anderson, are you able to have an in-depth conversation with Mr. Coleman right after this hearing?
I am, but I'm hopeful I can speak one more time with Mr. Schmidt before I have that conference with my client.
All right, Mr. Schmidt, would you be available to go speak briefly with Mr. Anderson before he calls his client, Mr. Coleman?
Yes, I can be available right after this hearing.
All right, so what I am going to do is schedule this matter 3 o'clock today for a status, an update, a final pre-trial. All right? Mr. Coleman, you need to make yourself available at 3 o'clock today. You may call in just as you have done here today, okay?
Okay.
Mr. Anderson, 3 o'clock today. Mr. Schmidt.
At 3 o'clock, what I'm going to be asking the court to do is ask the defendant to acknowledge that he has seen the body cam and that he's still rejecting the offer. The state's main concern is Ludwig,
all
not
of that stuff,
yes.
but I can't say that he's seen the body cam because I'm going to guess that he's not going to be able to see the body cam because he's at work. Mr. Anderson is at probably his job too, doing court stuff in other courts or at his office. All I can say is that he's probably going to go over exactly what happened on the body cam with Mr. Coleman, go over his thorough negotiations, settlement negotiations with you, with Mr. Coleman, and he's going to have a thorough discussion with Mr. Coleman of the ramifications of the evidence in this case and what it means for Tuesday. That's all I know, and I'm going to go over with Mr. Coleman at 3 o'clock if he understands the agreement or, the offer that's been presented, and if he wishes to accept that offer or formally reject that offer on the record.
Okay, thank you.
And then we will see where we're going at 3 o'clock. All right?
Thank you.
Mr. Anderson?
Yes, it's fine.
All right. Then everything's good, and So once we adjourn, Mr. Schmidt is going to go right back to his office, going to expect a call directly from Mr. Anderson, and then Mr. Coleman, expect a call directly from Mr. Anderson, okay?
Okay, can you tell him that I'm gonna call his office with the phone number that he can get a hold of me on?
Yeah, do that right away. 'Cause I'll be talking to Mr. Schmidt.
I'll do that right away. I'll call your office with the phone number and call me back on.
All
Okay.
right. Thank you.